Hello, in this video I shall be giving the analysis of a topic. The topic is Need for Necessary Reforms in Criminal Jurisprudence. Jurisprudence is the role of law or legal system in the society. It is the theoretical study of law. So what reforms we need to bring in the criminal jurisprudence in our law, and why do we need to bring? So this is because we need to have more concern about victims in our criminal jurisprudence. The victims have to have more focus on them, even in the pre-crime level and in the post-crime level. We shall see that how. And for this reason and to this end, there has to be change in our criminal justice system. And judicial initiative must also be coupled with legislative enterprise. So there has to be legislative involvement, legislative recognition of victim and the justice to the victim, along with judicial initiative, not just giving justice, but there has to be law to this end. And the ground realities are far from black letter of the law. As we can see that the realities of the victim after they are sent to this through all the trials, the realities are very far from the law. The law says that this justice is very easy and it can be ensured well, but the ground realities are far from that. So what reforms can we bring to ensure that victims are given good position even after the crime? So this is our analysis. For that reason, we shall see in what ways we can prevent the crime, that is pre-crime level. So pre-crime level mitigation, pre-crime level take-up can be crime prevention. So crime, if it is prevented at the first stage, the victim is saved from getting victimized. So this has to be the view. But this is very much least studied aspect in law. In law, we always speak about the post-crime things, what trials happen and how a person is convicted after getting accused and all. But we need to study right from the pre-crime level, and this has to be given focus upon. This is by examination of crime prevention. So this crime prevention must be examined. How we can prevent crime must be first investigated upon, must be studied. And situational crime prevention. So how crimes happen and what situations lead to crime. So this situational study must happen so that to avoid these situations. So this must be the view. And risk mapping and vulnerability mapping must be done. That is where most of the crimes happen, in what areas, in what kind of areas. And this risk mapping must be done and vulnerability mapping must be done. Who are going to be victimized? Basically, we know that women, children, disabled, the old and all. So such vulnerable sections of people who are subjected to crime must be mapped. So just mapping is not sufficient, they must be given protection. So these potential victims must be given prior protection through one-stop centers or in whatever way the police can take up. So this is how we can prevent crime. And capacity building. Capacity building is through setting up police stations or one-stop centers in those remote areas, and also involving NGOs who are willing to come forward as volunteers to help with these women and all. So that kind of capacity building must be done. And effective implementation of all of what we have spoken now is the main important thing. So this is how we can prevent the crime at the first stage level, that is pre-crime level. So this is like giving justice to those who are vulnerable to be victimized. And the next thing is post-crime level. So we know we have a lot of law regarding what to do after the crime has happened. So this post-crime level involves mitigation of crime and rehabilitation of these victims. So how well these victims can be looked after, and all of that is recorded or in law. So this is the post-crime level we are so much known about. But the pre-crime level is what we need to focus upon. And as I've told, the reforms that we need to bring in criminal jurisprudence, they must be in focus of ensuring victims' rights and needs. So ensuring victims' rights, recognizing that they have certain rights and ensuring their needs, assisting their needs, is what the whole scene of reforms that we need to bring revolves around. So these reforms I have listed as 6 over here, and we can come up with so many other reforms, but the basic reforms or basic view with regard to victims' justice delivery are these things. The first is access to justice. So the victim must know that he has justice thing working in the country and that he can have access to this justice. So this justice is ensured to him by certain constitutional basis, that is Directive Principles of State Policy, Article 39A in Constitution. So this states that the state must ensure that the victim gets justice without any discrimination. So the state must look after this justice thing in the state, that the victim is given justice finally. And the next thing is Fundamental Right Article 14. This ensures right to equality. And Fundamental Right Article 21. This ensures right to life and personal liberty. And the victim must know all about this. There has to be a victim-friendly procedure for right from the time of reporting till the time of the final justice delivery. There has to be victim-friendly procedure. The victim should not run from pillar to post for getting justice. He must work in a smooth way, and there must not be any inconvenience to the victim while all these trials are going on. So this is first thing. The second thing is effective participation of the victim. So the victim must effectively participate in all the trials and legal system that is going on, because his voice has to be heard. So he has the right to be heard. For that he needs a lawyer, and the state must assist this lawyer and all the financial assistance, that is access to legal aid. So for the legal aid, he must have access from the state. The victim impact statements must be recorded well. They must not be deaf-heard. And reporting to appeal, the victim must be looked after well by the state. So where a victim-friendly atmosphere can ensure this victim to effectively participate in all the trials, will give him finally a good justice. And the third thing is right to information. The victim must be informed about all his rights and his role in the criminal justice system. He must know, and the status of the trial he must know. The victim need not attend all the trials, but he must at least know the status, at what stage his justice is on the way. And entitlements as a victim. He needs to get certain entitlements from the state and from the accused as a victim. So what entitlements he can get? He must be known about all of this, and this right to information must be ensured to full extent. So this is a basic reform that must come in our jurisprudence of criminal justice. And the next thing is, the fourth thing is right to protection. The victim must be protected after the crime. So security must be given to him for all the court attending dates, for all the trials. And he must also be informed about the status of the accused. So what the accused is currently doing, where he is placed, and where his custody is there, and is he on bail or is he on parole. So this is the temporary release of the accused when he is promising of his good behavior. So this custody, bail, parole, in these conditions, the victim must be known that the accused is outside the station, outside the custody. So he must be ensured that he is protected from the accused. And the witness protection scheme must be in play. So we have a scheme called witness protection scheme, wherein the witnesses who are threatened by the accused and the family members of the accused, they must be granted protection. So this full extent of working of witness protection scheme will give rightful justice to the victim finally. And the next thing is concept of assistance. The victim must be assisted by the state. So the state must be a facilitator to victim, that it must assist him medically or psychologically or financially, in whatever way he needs assistance. This is also declared globally by the United Nations in UN Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power. So this is what is even given by United Nations in 1985. So this must also be incorporated into our system. And the final thing is right to compensation. So the victim must be compensated and restituted. Compensation is from state and restitution is from the convicted or the accused who caused victimization to the victim. So this state level enforcement and political will is required for the right to compensation. So the state governments must come forward, and the politicians must make legislations to this end. And criminal procedure, Code of Criminal Procedure, CRPC section 357A speaks about victim compensation scheme. So the victims must be given rehabilitation and compensation. They must be looked after by the state completely. So that is in what way they can be looked after and all must be pursued through specialized schemes by the state governments. So this must be ensured, and this right to restitution is also there for victims. This must be the fine or loss that victims get from the accused. So all of these, assuring all these reforms can finally give fine justice to the victims. So this is the topic for today, and thank you.